Hello, welcome back to Legal Brain. Today I'm going to discuss yet another important topic in exam point of view, that is contract of bailment. And in today's class, I'm going to discuss about what do you mean by contract of bailment and where it is defined under Indian Contract Act 1872, who is a bailor, who is a bailee, and different types of contract of bailment in exam point of view. So do listen to the class. So first, I would like to explain about what do you mean by contract of bailment and where it is defined under Indian Contract Act. So basically, by virtue of Section 148 in Indian Contract Act 1872, we get the definition for bailment. What is a bailment is defined under Section 148, and it says that when one person delivers the goods to the other person, or one person, delivers something. There should be a delivery of goods to the other person, and it should be for a purpose. There should be a purpose for it, and once when the purpose is accomplished, the person can, return it, or he can actually dispose it if it is directed by the person who delivers them. So this is the basic understanding of contract of bailment. I'll just, try to read the section. A bailment is the delivery of goods, as I've told you, by one person to other person for some purpose. There should be a purpose, and upon a contract that they shall, when the purpose is accomplished, when you're done with the purpose, when you have, achieved the purpose, then it should be returned back or otherwise disposed of according to the directions of the person delivering them. So there are mainly two ways. One is we can actually give it, we can deliver it, and we can get it back, or we can actually dispose it if it is directed by so and so, the person who is delivering it. So this is the basic definition of contract of bailment. For example, I am giving my car to you. So I'm one person, I'm delivering my good, that is my car, to you. So there is delivery of goods. I'm giving the car, to wash the car, okay, or to repair the car, whatever be that. So there is a purpose. The purpose is to wash the car or to repair the car. That is the purpose. So I'm giving the car to you, and in this situation, after once when the purpose is accomplished, that means once when you wash the car or once when you repair the car, the purpose is accomplished, and then now you have to return it to me. You have to give it back to me. Once when the purpose is accomplished, you can return it back to me. So this is regarding a proper goods. For example, I'm giving you a perishable goods, like I'm giving you some like fruits or vegetables to keep it with you for a particular period of time. And, after the period of time, once when these are perishable goods, for example, this goods started getting decayed. If that is the situation, and if I am directing you, you can just dispose it off. You can actually dispose it off. That is there in the definition. You can actually return it back, or you can dispose it off. It depends on the goods that you have, and also based on the directions given by the person delivering it to you. So this is the basic definition of contract of bailment. I hope it's clear for you. And if you have any doubt, do comment below. I'll be responding it to you. So next is, what are the essentials, the essential criteria? The first one is that there must be a free consent. Free consent is an essential criteria. We have learned about free consent in contract 1, that there should be free consent, which means there should not be coercion, undue influence, fraud, misrepresentation, mistake, and so on. So there should not be anything like that in the contract of bailment. It should be like, with free consent. And there must be free consent for bailment from both the sides, and the bailee must have the intention of physical possession. So before that, who is a bailee? The simple definition is that the person who, for example, I've told you an example, like me delivering the car to you. Myself, I am the bailor. The person who is delivering the goods to the other person is the bailor. The person who delivers the goods, the particular person is called the bailor, and to whom it is delivered, that person is the bailee. I am giving my car to you. I am the bailor, and you are receiving the car from me, and you are the bailee. So the bailee must have the intention of physical possession. That means, physical possession means, there is a concept called ownership and possession. Ownership means a person who owns the property or owns the good, the owner who is having the title. And possession means the person who is having the physical possession of it, not the ownership. So bailee should have an intention to have a physical possession of the goods that the bailor delivers to him. And this is defined under section 148. I hope it's clear for you what is section 148, contract of bailment. And now, we have discussed about contract of bailment. The term bailment refers to a legal relationship between two parties in common law concept, and where assets or property are transferred from the bailor to a bailee. There should be physical transferring of, the possession of the goods or the property from the bailor to the bailee. From now onwards, I'm going to use the word bailor and bailee instead of one person to other person. And in this relationship, the bailor transfers the physical possession of the piece of personal property to the bailee of a certain period. It should be given for a certain period. For example, like 1 week or 1 month. There should be a stipulated period of time, but it retains, the ownership will be with the bailor. It is just the possession will be with the bailee. So there are again different types of bailment. I'll tell you that in detail. So before that, who is the bailor? I told you the person who is delivering the goods to the other person, or the person who is giving the possession of his personal property to the other person is called the bailor. And who is bailee? Bailee is the person who receives the particular goods, or the person who is taking possession of the property and gives back the property after the fulfillment of the purpose of the bailment is called the bailee. So you know about who is a bailor and who is a bailee and what is contract of bailment. And I have given an example. You look into the screen. Before that, under the bailment, normally the bailor has no right to use the property when it is under the possession of the bailee. And it says that the bailor has no right to use the particular good. For example, I'm giving my car to you. Now it is under contract of bailment, and I'm the bailor, and now I have no right to use the property when it is under the possession of the bailee. But the bailee has a superior right over the property. At that period of time, during that course of period, the bailee will be having the superior right over the particular property or the goods. And there's a simple example. A gives his car to B for repair, and here A is the bailor and B is the bailee. And the purpose of the bailment is expressed by A, that he wants to repair the car by B. So this is the contract of bailment. And now I'm going to discuss about the essential features of the bailment. So it is the basic essential features of the bailment includes there should be a delivery of goods from one person to other person. That means, the delivery of goods from the bailor to the bailee. So there are mainly two parties. And so two parties are very essential element of contract of bailment. And the contract oral or written or implied or expressed. The particular contract can be of oral, written, expressed, or implied. And next is movable property. This contract of bailment, we are transferring or we are delivering the property from the bailor to the bailee. So that particular property or the goods should be a movable property that, it will be like transferable from one person of one place to other place. As a main feature of bailment, that it is only for the movable property and not for immovable properties. So bailment is only for movable properties. For example, the common example is availing locker service from banks. For example, you are keeping your gold in your bank. Okay, so you're availing the locker service system in the bank. In this situation, the banks are the bailee and you are the one who is giving the gold. So you are the bailor and bank is the bailee. And the person keeping these belongings in such lockers is the bailor. So they both agreed upon some consideration, that is, bailor uses the locker, and in turn, the bailee charges the consideration for providing the services. There is an element of consideration in that. That means, when I am keeping my gold ornaments in a bank locker, I am the bailor and the bank is the bailee, and there is consideration. That means the charges. I'm going to pay the bank a certain amount for keeping my gold in the locker service system. So there is consideration concept in this. That is the charges that I'm giving to the bailee for the safe custody of my gold ornaments. So this is an example of bailment. And next, actual and constructive delivery. So I was discussing about, even in the definition section 148, there is a term called delivery of goods. So how can we deliver the goods? So there are mainly two, types of delivery: actual delivery and constructive delivery. In which actual delivery meaning is, if the goods are physically given to the possession of the buyer, the delivery is an actual delivery. Like me giving my car to you, I'm like physically giving the possession of the car. Now the car is in your home, not in my home. So that is an actual delivery. That's the meaning of actual delivery. Next is constructive delivery. Constructive delivery means the transfer of goods can be done even when the transfer is effected without a change in the possession or custody of the goods. For example, I'm giving, I am actually giving, I'm bailing my certain, an equipment, okay? Let it be an equipment. I'm delivering, or like I am bailing a certain equipment of mine to you, okay? It is like there is contract of bailment, there is a contract, but the possession is not with you. Still, I am keeping the particular equipment with me and I am using it. That means I am under contract of bailment, but I am not giving the physical possession. The possession is still with me. So that is the meaning of constructive delivery. Without giving the possession to the bailee, the bailor will be having the particular equipment. That is constructive delivery. So section 149 speaks about delivery to bailee, how made, and says that the delivery to the bailee may be made by doing anything which has the effect of putting the goods in the possession of the intended bailee or of any person authorized to hold them on his behalf. So this is the concept of delivery. And I'm going to discuss certain key takeaways, from all these topic that we have discussed. Bailor involves the contractual transfer of assets or property from the bailor, who temporarily relinquishes the possession, but not ownership to a bailee. That means the bailor will be having the ownership, but not the possession. And the bailee must attend to the bailee must attend to and actually physically possess the bailable chattel or asset. That means the bailor will be having the ownership and the bailee will be having the possession. And there are three types of bailment. I'm going to discuss it to you. I'm going to discuss it. And although the burden depends upon the type of bailment, so there are the burden, like the liability depends upon the types of bailment, and the damage or loss to property due to negligence of duty of bailment can result in a legal dispute. So I'm going to discuss what are the different types of bailment, so that it will be easy for you to understand how the liability works in contract of bailment. So regarding classification of bailment, the first classification is gratuitous bailment. So a gratuitous bailment meaning is that a bailment made without any consideration for the benefit of the bailor or for the benefit of the bailee is called a gratuitous bailment. That means there is no concept of consideration or any kind of charges in this particular concept. So in simple words, a bailment with no consideration is known as gratuitous bailment. And in this, now I'm going to discuss about the concept and I'll discuss about the examples later. The second one is non-gratuitous bailment. Okay, non-gratuitous bailment means the bailment which is given for the sake of reward. There is a reward concept in this bailment. So it is for the benefit of both the bailor and the bailee. And third category is bailment for the benefit of bailor. So it's just purely for the benefit of the bailor. And next is bailment for exclusively benefit of the bailee. So it is purely for the benefit of the bailee, only for bailee, not for the bailor. And fifth category is bailment for the benefit of the bailor and bailee, for both persons. It's benefiting both of them. So now I'm going to discuss the example so it will be easy for you to understand. The first is bailment that benefits both the bailor and bailee. I've discussed, a kind of bailment in which is beneficial. It's benefiting both bailor and bailee. So let's see how that works. Example of service agreement. Okay, service agreement, that is a bailment. And for instance, parking your car in a paid parking lot. Okay, I am parking my car in your parking lot and I'm paying for it. So it is like mutual benefit. Like I'm getting a benefit because my car will be safe. I am parking it in your parking lot. And you are also getting a benefit because it's, I have to pay to you. There is a charge. There is a consideration to that. So we both are getting benefited out of it. So this is called bailment that benefits both bailor and the bailee. And next is bailment that only benefits the bailor. Here the benefit is only for the bailor and not for the bailee. So this is referred to as gratuitous or like free bailment. Examples: free valet parking. For example, you're going to a restaurant and there is free valet parking of your car, and you are giving your car to the particular person in the restaurant, and he himself is parking it in the parking lot. Here, only you are getting the benefit. The particular restaurant owner or they are just providing a service, a free service, and they are not charging for it. So they are not getting any benefit out of it. It is only you who's getting the benefits. This is called bailment that only benefits the Bailor. Next is bailment that only benefits the bailee. For example, taking a book from the library. For example, you're taking a textbook from the library. So here you are the bailee and the librarian is the bailor and you are the bailee. So here only the bailee is getting a benefit out of it. You are taking the textbooks and you are reading it. It's only benefiting you, not the bailor or the librarian. So this is the meaning of bailment, that only benefits the bailee. So next is, so these are the different types of bailment. I hope it's clear for you. And now it is, a bailment can be terminated in the following situation. So in what all situation you can terminate a bailment? First one is when the purpose of the bailment has ended. I've told you by virtue of section 148, it clearly gives that there should be a purpose when we are delivering it to the other person. So once when the purpose is accomplished, for example, the bailor is giving the car to repair. Once when it got repaired, the purpose is ended. And this contract of bailment is like ending. You have to return the car back. Next is at the end of the fixed term. For example, you have delivered a particular goods to keep it in the godown for 1 week. So once when the period of time, the fixed term is 1 week, and once it's got ended or expired, you have to get it back to me. Next is if the bail property is destroyed. For example, I've given you the property, and if there isn't that property for the bailment, then the bailment will naturally end. Okay. The next is one party gives notice of termination. So there is, we can terminate the particular contract of bailment by giving a notice. So again, there are different modes for that. I'll discuss it in next class. So do watch your legal break. And if this is the situation, this can also be a ground for termination of the bailment. So these are the different grounds in which a bailment can be terminated. So in today's class, we have discussed about what do you mean by contract of bailment, who is a bailor, who is a bailee, what are the different types of bailment, gratuitous bailment, non-gratuitous bailment, bailment based on like a reward, free bailment, what are the different examples for it, what are the different grounds in which bailment can be terminated. I hope that's clear for you. If you do have any doubt, do comment below. I'll be replying to you. Thank you for listening to Legal Brain. Thank you.